Okay.
Yeah, we need to talk about
Hi,
that
this is
too.
Marianne Talbot from the Children's Rights Council of Cleveland. We're child support and child custody advocates.
Okay.
We're live the first Wednesday of every month at 7 p.m. on kazradio.org. Or you can listen on demand anytime by logging on to kazradio.org.
Good evening.
You must be cute. You said one
And that's when I started. Don't start with me. I don't want to screw up another opening with you. Good evening. You're listening to Children's Rights Council of Cleveland, correct?
Correct.
We are still
Radio
in Cleveland.
show, right.
Well, I know it's the radio show. They know it's the radio show because they're listening to the radio
No,
show.
we have a new set now, so you wouldn't know it's radio.
No, it's television
I
because I'm on
know,
TV
right.
right there.
No more headsets.
Wow, this is great.
We have great guests today.
We have a guest.
We do.
But who are you?
I don't know. You're supposed to say that.
Oh, you're Marianne Dybeck of the Children's Rights Council of Cleveland, soon to be of Washington. She's getting promoted. Is that still in the works, or was I
Yes.
not supposed to say that?
Yes, but it's only 3 days a month. Don't even panic, people. Okay, I got all the hate mail. I'm still going to be in Cleveland. Don't worry.
And our real guest for the evening is Judge.
Diane Palos.
Well, no, I knew that.
Okay.
She's looking at me like, oh my God, you forgot my name. No, I didn't know if because you're the head judge, are you not?
The administrative judge.
The administrative.
Yes.
That was what I was looking for. Of Cuyahoga County.
Domestic Relations Court.
And I need to thank you because the gentleman you replaced, I'm not going to say anything bad about him. I'm
Okay.
not. But I swore the day I met him that I would retire from Fathers and Mothers for Equal Rights the day he was no longer on the bench. And that's exactly what I was able to do.
But yet you're still here working with us.
I'm here because you asked me to help out.
And you said yes.
And I said yes. But if you would like to call in and ask the judge a question, Marianne is hiding my phone number, you can call 646-478-4905. That's 646-478-4905.
And now we're going to go directly to Judge Palos. Judge Palos is here today talking specifically about pro se litigants. So we have a couple emails from members who have questions, and I can't read most of this, but
Get to the point.
Diane Palos already read this, and it basically talks about the woman wants to know if a child has the right to make a decision of where he or she is going to live based upon the age. Would you like to-
At 11 years old, the child can pick which parent they want. You don't need to bother the judge.
That's
with
what we
that.
all think, but
No,
that's why.
that's so far from the truth, it's
Right.
not even funny.
Yeah, there were actually, that was the law at one point, that during
Right,
a
I
divorce,
remember
the
that.
child at 11 could elect, or after a divorce was final, at 12 they could elect, but that hasn't been the law now for, I don't
30?
know.
Has it been that
It was
long?
the law when I started, so it's 20 years probably. I think it
Yes,
was
it-
around 91.
Right, a lot of people remember that
Okay, because
law.
I was going to say, when I got
Right.
involved in '94, my ex told my 6-year-old all he had to do was stay with me for 6 years because when he turned 12, he was gone. And of course, that wasn't the case.
Right, it does get a little complicated. So your comments on that?
Yeah, basically, that's not the law. The law doesn't give the child the right to choose, because we don't want to empower children, or more than empowering them in a negative way to be able to hold their parents hostage on these kinds of situations, but more than that, we don't want to put them in the middle on these situations. Really, parents need to be the adults and to make these decisions and have a parenting plan that's effective for the children. Now, I know that there's a lot of cases where people are uncomfortable or the children start to have issues, and they assume it's because of the visitation, and that may be true. But nobody should take that into their own hands. They should file a motion. But this is a very costly thing if somebody is going to do a post-decree that's after the divorce, possession modification. They're going to have to file a motion. They're going to need expert testimony. A child's therapist would testify, but that person isn't they have a different role. They're not there as an expert for the court, and they often don't want to testify because in treating the child, they have ethical issues and they don't want to come in and testify, and they're not an expert who would do a neutral evaluation. They're not neutral because they're treating. So you'd have to hire another therapist as a neutral evaluator, and we're talking about minimally, $4,000 or $5,000 probably, and upwards to $13,000 maybe, to do an evaluation of both parents of the children, reviewing the other kinds of information. So that's really what you're looking at. It's a pretty big undertaking. Now, not every case maybe needs that. There may be some instances where the child has some very clear issues with a parent. If you have a teenager, an older teenager who has some clear issue and a very articulated issue, and is a child who, can express themselves and is otherwise a competent, child does well in school perhaps and can explain what their needs are, you might be able to have a guardian ad litem that's a lawyer for the child, interview the child, and do some, again, collateral sources, look at the other kinds of people who are involved and make some kind of a recommendation. It's hard to know, but the child there's never an age where the child gets to pick, and it seems sort of simple that, at some point you would say, well, the child doesn't want to go, but by letting the child make that choice, you're sometimes doing something sort of damaging, which is putting that child as the parent in the relationship.
Right.
Empowering the child to have a say-so is a good thing.
Right.
Letting them participate by some kind of family therapy, by having the guardian represent them, those are good things. Letting them just decide, not so good. And often when people come in with these kinds of things, just because they say that a child's having difficulty, we can prove that objectively with school, grades, perhaps therapists, testimony, that sort of thing. But we can't always prove that it's due to the other parent.
Right, good point.
And often in this custody litigation, each parent is blaming the other one. Each parent is saying the other parent has done something to the child or is causing this problem. So it's never going to be that simple where the child just gets to come in and talk. And the law says that if a child is asked to be a witness in a case, which they can be interviewed by the court in their own case, they have to have a guardian ad litem. That's a lawyer appointed for the child. Court has a list. Those people are specially trained. The list rotates. And by local rule, we pay our guardians $125 an hour.
Who's we?
Well, our county has that rule that our guardians are paid that much. The parents pay it. So you're going to end up spending several $1,000s on that guardian. But again, there's issues, and you need to do that.
Right. So that's the best way for them to handle this, if they have those issues, is to not just withhold visitation willy-nilly, but actually approach the court and see
file a motion,
what they have to do to alleviate the stress.
And actually, what's sort of good about this may not be the right issue for that, but this is a good place for me to tell you that we have picked back up our mediation program. We had a mediation program, but our court person who was doing the mediation became a magistrate, and so for the last several months we haven't had an in-house program. Starting on Monday, we will have 2 part-time mediators who we have contracted with the Department of Justice Affairs through Cuyahoga County and the Office of Mediation, and they're a supervisor and 2 mediators who will be specifically contracted for and assigned to our court, will be located in the court in the Family Conciliation Services space, and we will be able to refer possession disputes and parenting disputes down there to mediation.
Would that be their first step? Say they filed a motion to change the parenting plan. Would that automatically be their first step, is to go, would they be offered the mediation first, or would the magistrate or judge say, in this situation, I'm just going to appoint a guardian, which you two are going to have to pay for?
The way that our rule works is that we're going to do it for the divorce cases automatically, but we're going to do it on a discretionary basis for the post-decree cases. So if somebody filed a motion on that case, it's discretion of the magistrate, because often with the post-decree cases, people litigate repeatedly, and the magistrates generally have had more than, they've had some exposure to the people 2 or 3 times potentially, and they know if it's something, because we have limited budget and limited amount of time for mediation, we're going to try to start out with the new cases first, but we will do some of the post-decree ones. So in that instance where we're talking about a child, as I said, it's not exactly perfect for this question, because this is really, should this child be allowed to choose whether they should visit? And the answer is no.
Correct.
Can
Right.
they have some input into this? Yes, but you have to file a motion, and the best way would be to have a guardian, because the only way the child's voice can be heard in court is through a guardian.
But it's always going to be case specific.
Mm-hmm.
If anybody out there listening would like to get in and ask the judge a question, you can do that by calling 646-478-4905. And I do have a question when you're done with yours.
I'm done.
Back in the old days, you had when you filed a divorce, you got sent to family conciliation.
Right.
Is that still in place?
It is. Again, sort of as a caveat about all of the things that I'm talking about, back in the old days, we had over 125 people at the court, and because of the early retirement incentive program through the county, because of the county finances, about 40 people took an early retirement in the past year and a half, and so we are down to 69 people right now. So
Wow.
we had about 7 people at family conciliation, social workers and a psychologist and a home investigator. We have 3 people right now. But we have set up, this is actually
So
kind
you're
of,
hiring?
no.
Oh.
But-
We
actually-
all want to see you down there, Neil.
We have 3 social workers who are doing the evaluations right now. We just hired somebody new in September, and so that's not as many as we had before, but that's okay. As far as investigation, what we've done, and this is I think a really positive thing, this is the kind of things that our court has been doing in the county courts. We've been trying to work together to help each other, and what we discovered was that probate court had 2 full-time home investigators for adoptions, and they weren't always busy full-time. So we've contracted with them, and when somebody needs a home investigation now in our court, they pay a fee, and then we send the social workers from probate court out. They do the home investigation, they report back to us, the fee is released to probate court. So we're helping them pay the salaries for these people. We didn't have to
I know,
hire
I love
somebody
doing this show.
and have a salary and health benefits and things that, for somebody who would go out once or twice a week or 4 times a week even. So it's a really positive thing that our court has done in conjunction with probate court.
That's fantastic.
That is very good, because I've had members ask us about,
That must be
that home
because there's a new
investigation.
administrative judge.
it could be, it could be. Are we done with that? Because I have one more question before we go
Go
to
ahead.
your court services. The second question was from Linda, and she would like to know if the custody and child support legislation is statewide, or is it individualized by each court, like Cuyahoga County? Is everything the same statewide?
All of law is statewide, and what's interesting, most people don't ask about the state versus the county, but they ask about the state versus the federal government.
Right, yeah, they do. Right.
And the family law is very much state-driven. It is all state law. And historically, the federal government didn't get involved at all. What has happened over the years is that the federal government has gotten involved in legislating child support. So they create laws that they mandate the states to adopt in exchange for receiving federal funding, and that's how a lot of our child support law is driven. So that comes from the federal government, but the states adopt it and enforce it, and all of the counties are required to enforce the state law. The only thing that the counties do independently is each of the courts, and the courts are organized a little bit differently throughout the state. Because we're such a big county, we have domestic relations court, juvenile court, probate court, all divisions of common pleas court, and then we have several judges in common pleas court. There are some counties that have one judge who does all those different areas,
Yes,
or
right.
different slices of the pie. So at any given county, it might be a little bit different, but each county has the ability to create their own local rules. And the local rules just basically require certain how your filings should look and what something costs and
That's a good
timing
point
and
to make,
things.
because the
So-
court rules change.
and they
Right.
change from county to county. And one of
Yeah.
the things that people, and I teach at Cleveland State, and one of the things that I've always talked to the new law students about is the first thing you do when you practice in some area is find out the local rules. Every court has them. The Court of Appeals has their own local rules, and so you find out what is it that's required in that area of law and in that regional area.
Right.
So if you're going to come into Cuyahoga County, you need to go to our local rules, which are on our website, which I think is, I don't know, I always forget, domestic relations.
Yeah, I
Court
just
at
Googled
Cuyahoga
domestic
County.
relations, right, and it
Yeah, it
pops
comes
right
up.
up, yeah.
And our website is great, and
It is very good.
We've updated it and done all kinds of things in the
Right.
last year with it.
We've
And it's
noticed.
really interactive.
Yeah, it's much better than it was.
And we post things. In fact, our new mediation program, there's going to be an announcement posted on that probably tomorrow sometime by the end of the day. So anything new that's happening, people need to check. Our mediation rule, we adopted a new rule for our program about a month ago. That's on there. Articles about some of the things that the judges are doing, different kinds of things, all are posted. We have our local rules posted. So if people want to try to practice in our court, lawyer or pro se
se.
litigant, they can look at those rules and see what's required of them. And our forms that we require are on there, and we're pretty proactive. There's a lot of things that are required by law that have to be in judgment entries, and so we're really active in creating sample forms for people so that they can check off a box. The downside is sometimes we'll have a 14 or 18 page form and you're really only using 10 pages of it, and if you wanted to download it and edit it, that'd be okay. But if you want to be fully safe, you just print it and cross out the stuff that doesn't
Right.
apply. But at least you're in compliance. You haven't missed mandatory language that needs to be in there, certain kinds of findings that are required by law. So
Right.
we're really helpful to the lawyers that way. And it hopefully it's not necessarily easy for somebody who's representing themselves,
Right.
but at least it gives them a starting point, which not all courts do. And a
Right.
lot of people, when they're representing themselves, will look on the internet for generic forms that are they're not from Ohio, they're not from Cuyahoga County, they're from who knows
They,
where.
Yeah,
they don't
yeah,
look right.
so-
They don't look
They're
right.
rejected.
Right.
Yeah.
Yeah,
Right.
I've seen motions dismissed.
So I don't know if that
Yeah.
answers that question, but the only
Yeah, I
law that
think
we
that's
have
great.
is some local rules. Everything else is state law, and then there are some things that are required by the federal government more and more.
Okay, that's our questions from our members today, but you wanted to tell us more about the services that your court provides now, which I just love. You have this room 306, and that's what we call it in our office, so I'm not sure if that's what you guys call it. Is there a name for that?
We call it the information center.
Okay, because we just call it room 306. So this has worked out great for us because our members are never sure where to start.
Okay.
And most of the people who come to us are from First Call for Help, so we're dealing with more indigent clients who really can't afford even $100 for an attorney. So this has been, so far it's been a couple months since we spoke about that, and it's been pretty successful. They're able to go to the information center, right, and speak with a clerk or personnel who works there, and they're able to get the motions that they need. So this is really good. Even though it is available on the website, people are still confused
Right.
as to, well, what
Which
motion?
form, right.
And we can't practice law, so it's against the law for us to tell our members, oh, well, you need to go file this motion. We're just not allowed to do that. Whereas we can send them to the court, and they can explain their issue to the court personnel, and they come back with the motion that they actually need. And it is pretty user-friendly. I've had like 7 clients go through this process, and 5 of them have no problems filing their motions.
Oh, great.
So congratulations on that. It's very important for our pro se litigants because it can be difficult. There's many rules and regulations, and I've seen many pro se litigants file motions that were dismissed because of technicalities. So
That happens
very
a lot.
good, yes.
Well, first of all, just as information I said to you before, that we are down to 69 employees. So we have half as many employees, and all of the people who staff the information center are part of our enforcement services department. So they've all been cross-trained. This is one of the things
What
that
is
we've
it?
had to do. We have everybody doing 2 jobs or more than 2 jobs because of the economy and the fact that we've had so many people leave, and there's no budget money to add. We were able to add some key people this year. We had to get a social worker. We had to get some administrative people, but
One of them, you cost me an attorney.
say what?
They took my corporate attorney.
Oh, your corporate attorney's
Sorry.
now working for domestic? Yeah, sorry.
Anyway, the information department, the idea came from, we had a pro se task force in the court, a group of different people from different jobs in the court. We've been talking about kinds of things we needed to do, and we had some training from the Supreme Court of Ohio about what is the practice of law and what is just legal information. So
Right.
you're allowed to give information, but you're not allowed to give legal advice.
And there's a fine line
Right,
sometimes.
it's very fine, and it's
Right.
very difficult, and hopefully we're navigating it better now.
Right.
What used to happen was that people would go to our legal department. Well, our legal department isn't a public legal department. They're not lawyers for the litigants.
Right.
They're lawyers for the judges. So our work wasn't getting done because they were taking these, people from the street who were
I
coming
was
in asking
wondering
questions.
why they were sending people away.
Right.
Because I don't know how many people I've sent to the legal department in the
that's
past
not their
10 years.
job.
Go to the legal.
Right.
But you're right, they
That's-
used to take the clients
Right.
and they used to help them.
Right.
Yeah.
And so I think it's much more troubling to have a lawyer give somebody the right form than to have a non-lawyer do it. So
Right.
in working with the Supreme Court and in having multiple trainings on what is information, what is law, we came up with this idea that these clerks would do it. And they all volunteered and they were really happy to do it. And for them, it's been a really great thing because they get out of their other office, which doesn't have windows, and they get to go
Right.
upstairs, and they rotate, so nobody's up there too long, because it's stressful working with the public, and everybody gets a little bit of a chance to try that and to go back and do their other job. There's two functions that they do, and one is it's basically a quality control function. We've had for, I think it's about 20 years now, something called the Journal Department, which is a person or group of people who have approved our entries at the time at which the judges are signing them to make sure that the right language was in them. Because of all these federal regulations about child support, there's pages and pages of language that have to be in there, and people are always missing it and leaving it out. So we've had this Journal Department to approve these things, but it's a difficulty having one person doing that. So the Information Department approves the journal entries. It's part of the same job, because when a pro se comes in and asks, well, I want to get a divorce, what does a judgment entry for divorce look like? They know because they're approving the entries. And so they're kind of like full service. If somebody comes in and asks them a question, they will give them a packet. We have a divorce packet. They'll refer them to the website. They won't fill it out for them necessarily, but they will give them hopefully the right document. Now, if the person asks the wrong question, or is clearly asking them to do the work for them, they're not going to do it. They're
Right.
trained to say no, and they have to. That's an unauthorized practice of law.
Right.
But
you know about that.
yeah, exactly. So
Tap dance.
it's a little bit awkward, and
It is, and it can be. And it can be frustrating.
and because they're approving the journal entries, some people have said, well, is that practicing law? But it isn't. They're doing it under
right. Right.
the supervision of the judge.
Right.
And they're leaving legal questions to us. So they have a checklist on the judgment entries, and then if there's some kind of an error or a problem, they'll highlight it so that we get the checklist, we look at the highlighted part and say, oh, there's a legal question here, and then we talk to the people, whether they're represented or not represented. Did you understand that you're waiving your child support, or did you know that you needed to prepare a quitclaim deed for this piece of real estate? But they aren't making that judgment call. They're just pointing it out to us.
Which
So
is a big difference.
because
Right.
they work both ends, they help people who come in to ask a question, as well as they look at the entries before they're filed. They have a pretty full set of information now about what's happening there. And so they do have, they're like a clearinghouse. So they've kind of mixed it up, but they do basically sort of two different jobs, but that are related. And they will take, they'll take time with people if they need to, and they will give referrals to like 211. That's,
That'd be us.
yeah,
That's where we get our calls
Right.
from. Right.
right.
Yeah, that's what.
Or you
I
can
just
call
left court.
646-478-4905 and ask the judge correctly.
But we only have 2 minutes, so if you want to reach our
You want that
offices-
number said again?
Oh.
Look, we have a director over here who's trying to tell me what to do,
I thought
and
you
you
said we
keep
had 2
walking on him.
minutes.
He wanted me to say that the phone number here is 646-478-4905, or off air, you can call Mary Ann at 216-227-9111. Judge, did you want to give out a number that they can reach the court or call somebody? Or or you just want them to go to the website and get all their information out?
It's easier if they go to the website, and I don't know the number, which number we're using in 306. The main number is 216-443-8800, and they can ask them for the information center. But it's hard to do that stuff over the phone with the information
What-
center.
Right, yeah, I just usually send people down there. And they're happy to
Producer's
know
trying
about
to
it.
get
They're
your
like, "Oh."
attention, man.
One of the
Definitely.
things about the information center I'd like to tell you too is that there's a workstation there that has been contributed by the Cleveland Metropolitan Bar Association. There's 3 rooms, and the middle room has 2 computers and a printer donated, by the Bar Association, so that lawyers can work in there too. So if somebody comes in and has a question, they might actually meet a lawyer, so that might
Yeah,
not be
right.
a bad thing, but the litigants can use that too if they wanted to just type up something. We have that ability to give them the chance to use our computer or to check our website there.
Right. And again, from Children's Rights Council's perspective, we don't necessarily promote pro se litigants. It's very, very confusing. You really need to know what you're doing, especially if you're going through a divorce, child support issues. Some people have to go pro se. Some motions are simple just to get yourself up into court. Like Judge Palos was explaining to us, if you have child visitation issues. If you can't afford to hire an attorney, you go down to the court, go to the information center, get the correct paperwork to file your motion to get it seen before a magistrate so you can discuss your issues. Whether you're going to go to mediation or what was the other option, is mediation or a
conciliation or hire a
ad litem
guardian.
appointed.
Yeah.
You need to file those motions. I get a lot of phone calls from mothers who want to withhold access, but they want to do it the right way. And kudos to all of you women. You're the greatest. Go down to the information center, get the
Excuse
motion
me,
you
I
need.
don't think so. I don't want my children being withheld from me.
Well, there's 2 sides to every story, and the only
If I
tend
didn't
to
give you a
generalize
hard
those-
time, somebody would
That
think there
is
was
true.
something wrong.
That is very true. It's just I generalize because
I know.
I want to finish my spiel. Most custodial parents tend to be the mothers, so shame
One of
on
the
me
things I'd
for
like to-
generalizing a lot.
Excuse
I don't
me,
wanna
the
break up
judge
your
wants to
fight.
correct you.
What?
But
That's what we do on every show.
sure, that's excellent.
Yeah, we
really.
do.
Thank you for putting me in the middle. I'm like the referee at the tennis match. That's great.
Yeah.
I think it's really important that people understand that we shouldn't have custodial parents, and we shouldn't even use those words. The actual words have not been in the revised code since 1991, custodian.
Custodial
And-
parents?
Yeah.
Correct. It's
Not-
Wow, I did not
It's
know
allocation
that.
of parental rights and responsibility, and you're the legal custodian and residential parent and legal custodian.
Ah,
If
good
you are
point.
the sole person allocated with parental rights. If there's some kind of joint parenting, then it would be shared parenting, and both would be the residential parent. One might be the primary residential parent versus the other residential parent. But the language is all that. Those are a lot of big words and a
Right.
string of words that are often uncomfortable for people.
So there's no such thing as sole custodial parent anymore.
Not that word. But I'd like to tell people to avoid those words, because custodian
Right.
is a bad
It's
word.
kinda demeaning.
It's kind of demeaning.
Right.
Visitor, horrible word. Who
Oh,
wants to be
right,
a visitor for their
exactly.
child? It sounds like they're going
Right.
to prison.
We try to
you know.
use the word access when we're
Right.
talking about
Well,
that.
I really think it's important. I've been working on a project
Good.
with the Supreme Court for several years about this, and we're still working on it, that the law changed so that every case be a parenting plan be issued. Not shared parenting, but just a parenting plan, and that people really think about who's primary for residential, like school purposes, who's primary maybe for medical, who's primary for extracurricular. There's different things that people, for religious, there's a lot of different issues that come up, and maybe one parent's better at one thing than the other, or they could share them in some way.
So any parenting plan could be devised for
Right.
one parent. See, I never
It could
heard
be-
that either.
So you should just have a parenting
good.
plan. We want it, that's one of the things in mediation, we
Instead
want
of a
everybody
shared
to have
parenting plan.
a parenting plan. Right.
I know, especially Magistrate Kelly gets very hung up on calling it a parenting plan or a shared parenting
Mm-hmm.
plan or,
Well, because the
there's
words aren't
obviously
parenting, it's
differences.
in the statute for 20 years, but nobody ever it's so easy to say custodian because it's one
It is.
word. Allocation of
Now
parental
I've been in
rights
this
and
business 12 years, I
responsibilities.
should know better, right?
Right. But really, I want to tell everybody that this is the new thing, even if we've been working on it for 20 years and we haven't gotten there yet, and we're still working. And eventually, we're working really hard right now to get some age-appropriate parenting plans posted on our website. And we
Nice.
will have them in the next couple weeks, I hope. And then people will be able to devise their own parenting plan, and they'll have those age-appropriate ones, because we're talking about like the teenager who doesn't want to
Right,
visit.
right.
Well, maybe they don't want to visit, not so much because dad or mom isn't a
Right.
good parent, but because they've got their own life.
Right, exactly.
And so, what's right for them?
Unfortunately, that's our music. I
That's
would
it.
like to thank you. That was
That's
the
a very
fastest
quick-
half
Really.
hour in radio.
Sorry
It was
for that.
fantastic to have you. I want to thank you for all the changes you've made at the court. I wish it was this simple when I went through.
Yeah, we're very glad to see
We're
you.
working on it. Thank you.
And thanks for tuning in. We'll see you next month on CRC's radio show.
Thank you very much. Good night.
Good night. I think John's going to go to commercial up here. So I don't know when we're off the set, to be honest with you. I suppose we could leave the set.
Yeah.
I support shared parenting.
We're on.
Sometimes divorce is inevitable, but done the right way, more children like
I'm
myself
shocked
can be
when
saved
Phil
from this
came to
video
work
being
for you.
hit by the shot
Oh, that was
of
him?
disease.
Oh, you did tell me
Kids don't need
that. Was such a good point to bring up about the custodial. I often use that and I should not be.
it's easy, because it's one
word, but it's the
wrong
message.
Right.
Yes, all you parents, it's
I
as
learned
easy
a
as
couple
that.
things today. That's what I love about these shows.
buzzing while
So was mine.
I was thinking, I wonder if somebody's trying to tell me like to fix my hair or something.
Understanding of legal processes, including but not limited to your rights, responsibilities, and laws that apply to child support and child custody. Motion review. Attorneys are paid directly from our clients to review motions needed for court. The staff at CRC does not recommend that anyone file a motion without an attorney and review of the case. Court companionship. CRC's director or a staff member can accompany you to court to make the experience less stressful to both the client and opposition. Supervised visitation. If the court orders you to do supervised visits, CRC has a facility that fosters parent and child relations, including board games, miscellaneous toys and arts and craft, and finally, all the kids' favorite game, the Wii. We also offer free legal clinics, and of course you already know about our radio show. To reach CRC's office, please call 216-227-9111. See what we can do to help you. Think about what I said, parents. And you lawyers out there, too, who like to drag out these battles, remember the children. This is Jonathan, representing the child's best interest from the Children's Rights Council of Cleveland. Peace, Cleveland.